Hunter Biden is claiming immunity, and we knew this was coming, but it's not just immunity from his plea deal. It's immunity from basically everything that he's ever done, and there's a lot. We now know that there are 25,000 more emails plus that have been uncovered. Apparently, they're being stored away, tucked away at the National Archives. They don't want to disclose those documents to anybody, but America First Legal is digging into them, and we'll go through the numbers in detail. But first, this immunity situation, because Hunter, as we know, has been charged with crimes, totally joke crimes relative to the actual criminality that he's been involved in. But because of the sequence of events in this case, remember, he got charged with an information, which is basically a misdemeanor type of a deal. The plea deal was already settled. They were just going to walk in and sign some paperwork and call it a day. Well, that all went awry. Judge Norica threw the whole thing out, said, you guys are trying to pull a fast one on us. And so the government had to come back and then indict Hunter Biden. So the original information, the original charging document was kind of no longer needed, right? Because we've got an indictment now. The information is a much simpler charging document, and they were able to do that because they had a deal worked out. But now that they didn't have a deal, they needed to go establish probable cause, convene a grand jury, go through a formal indictment. So what has happened is Hunter's people are responding to the government and David Weiss. David Weiss filed a motion to dismiss the information, the original charging document, because he's supplanting it, replacing it with this new indictment. Well, Abbe Lowell, Hunter's lawyer, says you can't do that. You can dismiss, sure, feel free, but we already have an active diversion agreement that immunizes Hunter. Pretty simple filings, but this is going to be a big can of worms that they're going to have to unpack, and the DOJ is going to respond to this. And the DOJ, in my opinion, is largely corrupt, as is David Weiss. So we'll see if he fights this. We understand what's happening. David Weiss was responsible for botching the whole plea deal. He gave Hunter an advantage in the mess, which allows him to claim immunity. Now we're expecting the same guy who created that opportunity to defend the opportunity for a favored defendant. David Weiss worked with Hunter Biden's brother, Beau. So we see here, this is what David Weiss ultimately submitted. Not a long filing, pretty simple. This is coming from Leo Wise, actually from David Weiss's office. He was the actual physical person who was there in court when the plea deal got botched. Says, hey, the government is now coming through and voluntarily dismissing the firearm information. He got two sets of charges, tax and firearms, without prejudice because we got an indictment. Pretty simple. Says the United States here voluntarily dismisses the info. Why? A grand jury came back, returned an indictment. We got 3 felony counts. On June 2023, the United States government, through David Weiss, we originally filed a single criminal information. It's like a speeding ticket. Hunter, you know, like a little tiny little document. 2 crimes, illegal possession of a revolver and tax crimes. He had an initial appearance on September 14th, though. A grand jury came back, okay, because the plea deal got botched. So when the plea deal got botched, they did their initial appearance. They came back with the 3-count indictment. Hunter got charged formally with the 3 different charges, specifically false statements during a background check, false statement filling out paperwork, and the tax charge. They say, Your Honor, as you know, the 5th Amendment says that you cannot be prosecuted twice for the same crime. It says prosecutions for felonies must be presented and started by a grand jury. An information was filed in this case earlier, but at that time, because we had a negotiated plea deal. But that negotiated proposed diversion agreement included a waiver of indictment, meaning if Hunter signed this, we didn't need to indict him. Or if this was accepted, is the more accurate way to say it. At the July hearing, U.S. probation declined to sign the diversion agreement. So it was not ultimately in effect because probation did not sign it, says the government. Therefore, it did not enter into effect, and therefore, as a result, no effective waiver of the indictment was valid. Footnote 3. Specifically, they say, paragraph 1 of the proposed agreement expressly said that the term of this agreement shall be 24 months beginning on the date of approval of this agreement unless there's a breach. They say here, the version of this agreement, this is the prosecutor writing, David Weiss, so-called, says the agreement that Hunter docketed has an empty signature line for Miss Bray immediately below the approved by signature line. So Hunter cannot claim that the U.S. probation signed the diversion agreement, which was a necessary condition precedent to the formation of the agreement that he negotiated, because it did not. Okay, so the government is saying this deal that immunizes Hunter, which should have never ever been allowed in the first place, is not valid because one person didn't sign it. Oh my God. gosh, like, can you believe that? What if she would have signed it? Hunter is totally immune. So it's like, I can't believe she didn't sign it. I can't believe they didn't just squiggle a name on there. That's it. This is the same prosecutor's office who's now trying to fix this. Okay, the same people, the same team who botched this whole thing are now leading the prosecution. It is so rigged, I can't even explain it. Further, at the hearing, the court raised concerns about the proposed diversion agreement, whether it's enforceable or even constitutional, which was drafted by the DOJ, who are the same people in charge. I mean, shouldn't they have all been fired immediately? As a result, for trying to rig a plea deal that was unconstitutional, questioned by the judge, as a result, the court deferred the decision on the proposed diversion agreement, didn't accept it. And so thus the defendant did not waive the indictment, okay? Meaning he needed to be indicted again. So they did. So following the hearing, the court and the defendant, Hunter, engaged in negotiations to address the concerns about the proposed diversion agreement. But as the government previously told the court, the negotiations did not result in an agreement. Because the parties could not reach an agreement, the government informed Hunter in writing that it was withdrawing the most recent version of its proposed diversion agreement. They say, here, in addition to the Fifth Amendment and the rules, Hunter must be charged by indictment, and it must be done in a speedy manner. And so the government did that in comportment with the speedy trial rules. That's why we brought our indictment on September 14th. We did it in time, so we're not out of time there. So they say, with all of that said, the information should be dismissed without prejudice, right? Meaning the case is still active. The information is gone. It's just been replaced by the indictment. So now we've got 3 felony charges. Now, pretty simple. Seems pretty obvious. Here's what Hunter's lawyer says, Abbe Lowell. Very simple filing claiming immunity. And they're going to stand by this. And this is what they should do. This is great legal work. And they had it set up for them by Biden's own DOJ, right? I'm less and less skeptical that, I think this was probably a mistake. Like, they would have liked the plea deal to have gone through, obviously, because that would have been absolute immunity. But this is the next best thing, is just to say that it got messed up and to have the same people who couldn't get it through the first time botch the fix, right? Have them screw up the fix. So here they say this is Hunter's response. Defendant Robert Hunter Biden. We submit this response to the special counsel and we say, we begin this matter by noting Hunter's disagreement with much of what the special counsel asserts in his motion. We disagree with much of what you just said. Most notably, Hunter maintains that the standalone and bilateral, 2 words that he pulled out from the transcripts, it's on its own and it's bilateral, meaning 2 sides. So Hunter is actually doing things. Hunter is complying by the terms of this. That both parties signed, they say it remains in force. Prosecutor signed it. Hunter signed it. We don't need probation to sign it. And he will seek to dismiss the indictment against him pursuant to the immunity provisions of that agreement. There it is. The whole thing, okay? The full indictment with all 3 charges. He's going to seek to dismiss it because of the immunity provisions. The only charge that special counsel was permitted to bring under the diversion agreement is the charge and the information. And if the special counsel no longer wishes to pursue that charge, it has the right to do that. And he knows that he can't do that now because the case has been botched. There's no deal for the information. The information was based on the deal, that Hunter would sign that deal. He's obviously not going to sign that. So, and the government is not going to bring that case because they got called out on that by Judge Norica. How dare you bring this unconstitutional, ridiculous case type of plea deal? And further, Hunter's position is that the enforceability of the diversion agreement has no bearing on the motion to dismiss, and any disputes about the diversion agreement are not before the court at this time. Signed by Abbe Lowell. Just amazing. So that, I think, is going to be an interesting debate, and watch us wake up and David Weiss just like, oh, sorry, I guess we screwed it up. I guess Hunter does get immunity after all because we botched it. Or did they botch it? Or is this how they wanted it to go from the very beginning? So very, very interesting stuff happening there. Now, the question is, are we going to see more charges against Hunter? Because there's a lot more smoke here than we even thought. And Joe Biden has been missing in action. Now, Byron Donalds confirmed this for us. He says, Americans are being killed and held hostage by radical Islamic terrorists in Gaza. And where's Joe Biden? On Saturday, Joe began making calls 8 hours late, and he spoke for under 3 minutes, took no questions. On Sunday, he called mid-morning, a mid-morning lid, meaning he's done for the day, and then he held a barbecue. And on Monday, he called a pre-noon lid. This is basement presidency in action. Byron sharing this one, okay? Monday, October 9th, 11:52 a.m. before noon, for crying out loud. They said to the Wranglers, which is all the press people, they say, hi everyone, the White House has called the lid for the day before the pool call time. We will not be seeing the president today. Isn't that interesting? So that's pretty curious because there's a lot going on in the world right now, if you haven't noticed that. So the question is, where was the president? Well, we now know about this. He was being interviewed by the special counsel, and this was the statement that was released by the spokesman for the White House, Ian Sams. Remember that Joe Biden has his own classified documents problem, although the FBI didn't raid his house and smell Dr. Jill Biden's, gosh, I can't even finish the thought, like they did to Melania. So they instead are giving Joe all sorts of benefits, and they release this little statement. Joe Biden's been missing in action, and apparently he was being interviewed for criminal charges that will never come, even though he was not the president, did not have the power of the opinion clause, had no right to take these classified documents out of anywhere when he was a senator. The documents were at multiple locations, and Hunter Biden had direct access to them, and Hunter was working with foreign companies as an unregistered foreign agent. Slightly problematic, but the media didn't talk much about this at all. Instead, this little statement comes out, says, the president has been interviewed as part of the investigation being led by special counsel Robert Hurr. The voluntary interview was conducted at the White House over 2 days, Sunday and Monday, and concluded on Monday. Joe Biden took his break for a Sunday barbecue. As we said from the beginning, the president and the White House are cooperating with the investigation as it has been appropriate, and we have provided relevant updates publicly, being as transparent as we can, consistent with protecting and preserving the integrity of the investigation that's being run by his own DOJ. We would refer other questions to the DOJ at this time, and of course, Biden runs the DOJ, and they're covering up for him as they've been doing since, well, 2019. So very curious. Now, we know that the White House has lied a lot about this. In fact, on our members only stream this morning, we had a conversation about an article from CNN where they confirmed that too. They said, well, we kind of get lied to by them, but we like being lied to because they like to be abused by their own government for whatever reason. But there is a lot more here. America First Legal, a great follow over on the X platform, has been doing some great digging on this, and they tell us there is a lot more here. So for all of the no evidence leftoids like Dan Goldman and others who are out there saying that there's nothing to confirm the Republican suspicions, here are some numbers for them. From America First Legal at America1ST for First Legal on X, says, breaking, our Freedom of Information Act lawsuit against the National Archives has now revealed that the then Vice President Biden's office had the following emails. 19,335 with Rosemont Seneca, Hunter's business. 4,000 emails, 4,243 with Hunter Biden to the Vice President's office. 1,750 emails with the brother Jim, and 3,738 emails with Jim Biden's Lion Hall group. Now, this comes over from a status report. Sounds like America First Legal is suing the National Archives, as you can see here on this document. And this is an update to the court. Pursuant to the court's order, America First Legal and the National Archives submit this joint status report. They're suing, saying, we want access to all of these materials. The National Archives says we can't give it to you. And the judge says, well, you have to give some stuff, and so I want to know what the status is of the document disclosures. Here's what they excerpt for us. They say, through our discussions with NARA, America First Legal has requested that NARA bypass one particularly large set of records awaiting review. So the National Archives is like, wow, we're working really hard to read these documents. Trust us. We're going to read through them all, just one at a time, but we've got one guy working on it, and he's got a computer from 1994, all right? So it takes like 17 minutes for him to open up a record and confirm it. So it's going to take us about 700 years for us to get these files back to you, okay? Is that going to work for you? No, it's not. So the America First says that NARA, can you just bypass that guy with his Pentium 4? And America First has proposed narrowing the request. So we submitted a big one, but let's narrow that down. In response to this request, they use specific search terms. NARA has found the emails, the National Archives, going to Joe Biden, 4,000 emails to and from Hunter, 19,000 emails to and from the domains at Rosemont Seneca and SenecaGA.com, 1,700 emails to and from Jim Biden, and 3,700 emails from the domain LionHallGP.com. At the current processing rate of 1,250 pages per month, it would take, that's it, okay? How many pages per month? It's just crazy. 1,250 pages per month. They want Trump to go through like 1 million a month. It would take NARA more than 15 months to complete its processing of the request. 15 months. like right after the election, which is great, right? Definitely don't want us to see this before the election. So accordingly, on October 3rd, the AFL provided NARA with another list of search terms, and we've requested that NARA increase its monthly processing rate, okay? Get through the emails faster, and that is from America First. So monstrous amounts of evidence. There is a lot there. Over 29,000 or so emails from Joe, his VP's office, to Biden crime family associates. And I'm very curious. I mean, maybe those are all dinner plans. Maybe they're all talking about the weather. Maybe they're all just totally innocent, and the National Archives just doesn't want to disclose them because, you know, confidentiality purposes and so on. Now, I think that as more and more evidence comes out, it's going to become clear, and the people who were denying that there was criminality here, they're going to be looking pretty foolish when we start to see what's inside. Of course, my friends, we're going to continue to cover. Thank you for joining us. Thank you for hitting that like button and hitting the subscribe button and visiting robertgovea.com to sign up for our daily newsletter, and we'll look forward to seeing you on the next one.